Okay, so today I'm sitting with Brent Norling from Norling Law. Now, Brent tells me Norling's specialty are resolving complex commercial disputes, which is kind of juicy and really useful experience and information for people to avoid having conversations with people like Brent. So thank you for taking the time to sit with me today.
All good.
I want to get started with something basic. What is insolvency?
What is insolvency? So that really is just where a company or an individual cannot pay their debts as they're due. And so there's a few different ways that companies end up in like a formal insolvency. So there's liquidation, there's receivership, there's administration. They'll have their own little quirks and dynamics. Yeah.
And that's quite a low bar, really, not being able to afford your bills.
Yeah.
I think, and the reason I started with that one is because I think people don't realise how basic that really is.
Yeah.
So what can trigger a liquidation?
Yeah, so really it is, a liquidation is as a result of shareholders appointing a liquidator or creditors going to the High Court and appointing a liquidator. There can be a bit of a difference too in outcomes, but we can have a chat about that depending on which path they go down. At the moment, the majority of liquidations are commenced by the IRD that we see. So in April 2020, Grant Robertson told the IRD to relax its enforcement, which it did, which was to help with COVID. And what's happened since is every business we're dealing with that is in an insolvent position has owed debts prior to 2019, and they've just gotten deeper and deeper into debt. And the IRD really is the lender of last resort. So generally people pay their Bunnings and placemakers, that kind of stuff first, and then get into debt with the IRD. And now the IRD has really ramped up its enforcement. So for those who still have had their head in the sand, that's resulting in a lot of current liquidations.
Yeah, but it takes quite a bit for the IRD to activate that, doesn't it? Because you can have payment arrangements. And
that's actually, I suppose, part of the problem in some ways is the IRD will issue so many demands and they'll let it go on for quite a few years in some cases, and that can give people a false sense of comfort. They think they can, my head's in the sand, nothing's happening, so they just keep doing that. But there is an end point, and at some point the case officer at the IRD is going to pull the trigger, issue a statutory demand, and start that process. But what we're finding, because we do a lot of IRD debt negotiation as well, we're finding that the people who are engaging with the IRD, who are proactive in their communication, really open and honest about, look, here's the situation that we're in, this is how we got there, these are the changes we're making, and this is what we propose to do moving forward. People who present it like that, they're getting really good arrangements. We've seen, pre-COVID, it used to be interest and penalties and maybe a time arrangement was standard. Now we're seeing interest and penalty write-offs, sometimes core tax write-offs. We did one recently where the tax owed was 500 grand. We negotiated down to 80 grand and 3 years to pay. And so they're really trying to get rid of some of the bad debts, and they're really focused on what's the maximum recovery here. And part of that is looking at, if it goes into liquidation, what are the assets worth? And in most small businesses, they've got laptops and some furniture, and there's not a lot of value. Versus working with the business to help, they've got a plan to trade out. It's actually better to write off and do a deal.
I suppose it's like any creditor. If you've got open, transparent communication and a plan, you're going to get a much more warm outcome than avoiding it, hiding from it, not being transparent with your information.
Yeah. The difference, I think, though, is commercial entities can be a bit more principled. So sometimes if they feel like they've been dicked around, even if the commercial outcome is worse to pursue it, sometimes they will. Whereas the IRD is just not looking at it like that. They're looking at it from what's the maximum recovery for us. Is it to work with them or liquidate? So it's a bit easier sometimes to deal with the IRD.
And you touched on it a little bit before, but who can activate a liquidation?
Yes. Yeah, so there is a mix at the moment between shareholder appointments and creditor appointments. Generally speaking, there's a bit of a theme in the industry where the shareholder appointed liquidator is generally a lot more friendly to the directors who appointed them or shareholders, which means often there can be worse outcomes for creditors if the shareholders appoint a liquidator. So my message often to people is if the shareholders appoint a liquidator, try and get your own one in, because creditors do have an ability to replace the shareholder appointed liquidator at the beginning. And you see it time and time again. The data really speaks for itself. The proportion of shareholders and directors pursued by the liquidators that they appointed is so much lower than the creditor appointed liquidators.
So as a creditor, how would you go through that process?
So when a liquidator is appointed, there can be a creditors meeting at the beginning, and that's the opportunity for creditors to replace the liquidator. So if the majority of creditors in number and value resolve to replace the liquidator, they're out. Yeah, so it's really just about banding together, and we see it a bit in the construction industry where subcontractors are not paid in quite large liquidations. And when you're talking to the subbies, they're really kind of defeated. They just think, well, it's in liquidation. We've seen what happened with Mainzeal. It's just the lawyers and the liquidators and the funders who are the winners here. And they kind of just give up. Whereas, we've been pretty successful recently in just saying, well, if you have that attitude, that will continue to be your outcome. So you need to actually get together and appoint your own liquidator who is more likely... is just more likely to pursue the interests of creditors, because liquidators have things that they have to do and they have things that they can do. They have a choice of whether they pursue directors. They have a choice of whether they litigate or not. They don't have to do it. So it's about getting a liquidator in there who has a reputation pursuing these things, because often, like I said before, these companies are usually traded for a couple of years insolvently. So in those circumstances, directors do have some risks, some personal risk. So I'm talking to the perspective of a creditor. And obviously, if you're the director in that situation, you want to get a friendly liquidator in there. And to be honest, we do both sides of that. It just depends
who's paying
who's
you.
the client in the room. Yeah, exactly.
Yeah.
Yeah. But I do prefer to be on the side of creditors. Yeah.
Yeah, if you've knowingly traded insolvent, that's, you're outside of what your requirements are supposed to be.
Yeah.
Yeah. And so what happens during the liquidation process?
Yeah, so it's quite interesting, and it's one area that I think a lot of people misunderstand. So the first thing the liquidators do when they're appointed is freeze all the bank accounts, get their hands on all the assets. They've got to protect those, realise them. But then they just start going through all the bank accounts. They'll go to every bank and they'll ask for the accounts. They'll start analysing those. They'll be looking where the money's gone. And one thing that we see really commonly is directors take drawings. And most people in their mind consider it as a salary. It's like that's for the work that I've done. But the legal position on that is it's a loan. It's repayable on demand. So the first thing the liquidators are doing is going, here's your current account, pay it back. And if you have personal property, they're also freezing it. And so, we've done that so many times where it can be quite a shock to directors who in their mind thought that was their salary. And often there's a lack of education or understanding around those things. They can also look to void transactions. So it's quite common in that last 6 months, especially for directors to start paying down debts where they have personal guarantees. So to use the Bunnings and Placemakers example, they'll pay them because if they don't, they've got a PG and they're going to have to pay it personally. And then they won't pay the creditors who don't have personal guarantees. So the liquidators have the ability to claw all that back, put it into the general pool for creditors and then distribute it equally. That's the rationale behind it. Practically, what ends up happening is it just all goes to liquidator fees because they end up churning a whole bunch of time to pull it all back in, because of course no one wants to pay back money, so lawyers get involved, and then there's heaps back and forth, and sometimes goes to court. So the net position for creditors actually isn't even better most of the time, but that's what happens. Yeah.
Yeah, and you touched on personal guarantees.
Yeah.
As well, so that's something that can unravel. You know, people go, oh, but it's a limited company.
Yeah, and that's something that we see so many times is people don't even have an understanding of how many personal guarantees they've signed. So they're aware of the big ones like their lease, the placemakers, they know, but there's all sorts of terms of trades that they've signed and they don't even know. I've interviewed hundreds of directors, and one of the questions I ask in these situations, do you have PGs? Often they say no. And then I'll start like just rambling off some examples of where they might have signed, oh, actually I did sign something for that. And part of the reason for that is in terms of trades, it might be under, say, liability for payment, and it might be, you know, third clause in, the person who signs it is personally guaranteeing it, and, you know, elaborates on that. And when people sign, they really care about two things, and they're only looking for two things. What am I getting and how much?
Yeah.
And so they're not going through any of that, and that's a real problem. It's also a problem when, and I've seen this recently, where a director actually resigned, sold his shares, walked away. Then 2 years later, the company went into liquidation, and the creditors came back and said, well, you signed a PG. And so really important in those instances that you actually take stock of what have I signed whilst I've been a director, and, you know, go through that. And then as part of that exit, making sure all of those PGs are withdrawn. So at the time you withdraw it, you're still liable for any historical guarantee, but you can go to the creditor and say, I'm not going to guarantee anything you do from here. So go sort out whatever terms you want. So it's really about withdrawing those and keeping it tidy, because often people don't.
Well, they want their money back. And you've got some.
Yep, exactly.
Yeah. So maybe keeping a register of what personal guarantees that you've got floating around.
Yep.
Because a couple of years after the fact, you're going through your scent box going, oh, what have I signed?
Yeah.
It's going to be a mission.
Well, and some of them, especially kind of in that second tier lending space, the PGs are often backed up with general security agreements as well. And people don't in my experience, a lot of people don't understand what a GSA can mean. So not only do they get the guarantee called up, they're personally in receivership, and the receiver comes in, and it's immediate. It's demand same day. You can put them into receivership, and that means their bank account's frozen. The receiver can come in and sell any property they have, and it can be a bit of a wake up for people, and they're quite shocked. So yeah, I think it's about being very careful about what they're signing, understanding what it means, get advice. A lot of people skip that bit. They
do. And to build on what you've just said, I've seen 2 in the last month in the Tier 2 space. A lot of it's fast and furious. It's digital. It doesn't come through us. They just get a link text to their phone. They open it up. They do the digital signing, and off it goes. And 2 loans that the individual thought was unsecured did have that. If we feel that we have good cause, we can put caveats on your house. And so one of them was an invoice finance product where the person thought it was just, you swap in and out an invoice each month. And then the other was a fast and furious cash flow loan. Neither of them had been organised by us, but we were trying to help them untangle stuff. But those clauses are in there, and you mentioned it earlier, what am I getting and how much, and then not slowing down, reading all the fine print, and then doing what they say they're going to do with regards to repaying loans, so that stuff's not actually happening. So if you're a creditor, when should you take action on unpaid debts?
My view from a creditor's perspective is the start point is have a policy around your accounts receivable. Most businesses that I deal with in the small to medium space just don't even have policies. It's more like just ad hoc, issue an invoice, it's going to get followed up, maybe some automatic reminders come out from Xero. But my view is be very clear, whatever it is, what are you going to do in 14 days? What are you going to do in 30 days, 60 days, 90 days? At what point do you say, this is going to go external? And external could mean, a debt collection agency or a receiver or a lawyer, whatever it is. I think people need to be very clear on what they're going to do and when, and follow through on that. But ultimately, especially in an economic market that we're in now, I think the sooner the better. I don't think we should be letting these linger. I think the data is the longer it's unpaid, the less likely you are to get paid.
Yeah.
And also, I've been involved in countless liquidations where our approach is really aggressive, and when we get involved, it's usually been outstanding for a while. So we demand letter, 2 days to pay, and there's no need for more because they're going to pay or not. Yeah. And then straight into a statutory demand and liquidation proceedings. And the reason we do that is we don't want to liquidate the company, but that process puts maximum pressure on a debtor, and you want to be the squeakiest wheel because they're just prioritising it at this point. They're saying, well, who do I have to pay to keep going? And if you're the one that's potentially going to liquidate the company, you're their highest priority. So I've acted for many people where we've done that and they've actually got paid, and then someone else has come in after and it just hasn't been enough. So they haven't been paid. And then, if it's not long before liquidation, you might be talking to a liquidator about voidable because they might try and claw it back. But I would rather be in a position where you have the cash and negotiating with the liquidator than to be a creditor with little prospective payment. Yeah.
So for the business owner, we've already touched on personal guarantees. So I might move to the next one. What about other people who have guaranteed on their behalf?
They're often in a difficult position because they don't have all the information. And so that's really about, from their perspective, they're very vulnerable because they've given a guarantee. They don't have visibility on the business at the time it fails. And so there's actually very little that they can do. They're going to get it called up. They will have a right to pursue the original debtor, but then it just depends what's in the company. Which often is very little. Yeah, well, there was an article and stuff a couple of days ago about a situation where the elderly parents, they'd been made minor shareholders in order to get everyone comfortable with them guaranteeing an $800 and something thousand loan that after 12 months couldn't meet the loan conditions of, I think it was the refinance at that 12-month mark. And so that it eventuated, they sold the house, and that's kind of like the worst case scenario, but I see it on a day-to-day basis where people are trying to do something, they've got a deposit, they want to buy a business because it's not enough to buy a house, and mum and dad are going to help me, and it's all just so ill-prepared, like we were talking about before with that guy with the cash. But I think many times the person asking, the guarantor and the person guaranteeing don't fully understand what it is they're saying. Lack of advice as well. And that's the theme in terms of what we see when these things happen is they didn't get advice. If they did engage a lawyer, it's really it's really skimpy instructions of let's just document this, and they're not getting any kind of risk assessment.
So if your business is starting to feel a bit out of control, what should you do?
Get advice as soon as possible. And who you should get advice from depends on the situation. It could be an accountant, or it could be a lawyer. Depends on what the situation is. But the worst thing people could do is put their head in the sand and just keep on going. I think in New Zealand, kind of two themes that I think two cultural issues that we have is she'll be right, and that people put their head in the sand and just carry on. And so that's the go-to response that I see from the people who end up talking to me, which is usually much later. So being really direct, having all the hard conversations that need to be had early as possible is really, really important.
Mm-hmm.
Yeah.
Yeah, there's a Kiwi kind of relationship with money that comes into it as well. People don't talk about money. They don't talk about it when they're doing well, and they don't talk about it when they're doing poorly.
Yeah.
And there's that head down, I'll just trade out of it.
Yeah.
But then that's sometimes like a dog digging a hole.
Yeah, and I think there's a lot of shame
Yeah.
involved in it, because often people's identity is actually linked to their business and it's their baby, and they don't really want to admit that it's failing. So they just keep going. But I think we just need to get past that, because like from my perspective, when people come to me, generally it's way too late. They're coming to me when the liquidation proceedings have commenced. And at this point, usually it's inevitable that there's going to be a liquidator. We're just saying, is this a shareholder appointment or a creditor appointment? Are we restructuring the business and moving it sideways and trying to salvage it? But there are so many more options if they come earlier. And, one of the biggest options is around communication, because creditors get to a point where they just get fed up. They're sick of hearing excuses, or they're sick of just no contact, that they're just really principled at this point. So you got all the time pressure of the proceedings. Whereas if people came like 6 months earlier, you can put cards on the table, and you can communicate, because at the end of the day, creditors just want to get paid.
Yeah.
They don't want to liquidate. They just want to get paid. And if that meant like we had to put them on a payment arrangement, we'd be more keen to do that than go to a lawyer and start paying a lawyer to pursue you. So I think the earlier people get onto it, the better.
Cool. Well, on the Norling Law website, there's heaps of resources. So, if you're feeling a little bit nervous, it's possibly a good place to start, to sort of ease your way into it. And then if you want to have a conversation with someone, I'll leave contact information for Brent, so that you can figure out, what's happening for you and what you need to do next, whether you're on one side or the other of the conversation.
Yeah.
But thank you for sharing your time.
Yeah.
With me.
I mean, one thing I would add to that is we do offer a free 30-minute consult, which I think it's really important to take out the barriers to getting advice.
Yes.
So even if it goes nowhere, that's fine. I think it's better just to have a conversation and go from there.
Yeah.
Cool.
Thank you.
All good.